Good morning. Morning to members of the media. Good morning to the members of the media and others. Thank you for coming out this morning to this news conference, which we think is an extremely important news conference to bring to the attention of the nation, the public advice, as to exactly what has been happening as relates to the Estate Police Association and on the wider scale, the labor environment in Trinidad and Tobago as it relates to the special tribunal and in particular the actions of the chairman of the special tribunal in relation to how the judgments that he would have been delivering, which are clearly not in the best interest of labor and specifically not in the best interest of the Estate Police Association and the citizens. This morning I'm joined by my colleagues from Trinidad and Tobago TTNNA, Sir Edie Short, President Edie Short. Also have from CW the President General, Ms. Joanne Ojiri, Mr. Robert Otley, General Secretary of the Estate Police Association, First Vice President, Mr. Videsh Bagwandin, and from Steelworkers Union, we have the General Secretary, who will shortly join us on the table, on the head table here, right? Okay, why are we here? We feel compelled to bring to the nation attention a continuing issue that has been negatively affecting both the security industry and the Estate Police Association. The Estate Police Association is the sole representative body by law to represent estate police officers. As such, we are responsible for addressing disputes arising out of employment issues between the employers of estate constables and officers themselves. In 2014, G4S officers brought a case before the court, before the tribunal, regarding the estate constables who were entitled to overtime pay after 8 hours, in line with the provisions of the Security Industry Sectoral Order Minimum Wages Act. In a judgment delivered in 2016, ST 13 of 2012, the tribunal ruled negatively for the EPA. The chairman, despite acknowledging the definition of worker in the Minimum Wages Act, referred instead to the interpretation of worker in the Industrial Relations Act, a stance which remains debatable. In that case, he ruled that if the politicians decided to change the law to facilitate overtime after 8 hours, then the community will be disadvantaged and companies will fail. That despite the fact that the law already made provision for remuneration of overtime after 8 hours in the sectoral order security industry companies. So here you have a situation where he's making a ruling contrary to already established and settled law. The chairman further ruled that security officers, and I want to make this distinction here, that there's a difference between a security officer and an estate police officer. The estate police officer carries a precept under the Commissioner of Police, and the security officer does not. The estate police officer appears before the special tribunal. The security officer appears before the General Services Division of the Industrial Court. But here you have the chairman ruled that security officer, a section of workers that does not come before him, where he has no jurisdiction over, was not entitled to overtime after 8 hours. That is directly in contravention of the minimum wages sectoral order, savings and exceptions contained in the Minimum Wages Act. The direct effect in this ruling was that the security officers would have been robbed of tens of millions of dollars in overtime, because the Ministry of Labor, in wake of this ruling, indicated to Trinidad and Tobago, had it up on their website, that the security industry was a 12-hour industry And overtime will only occur after 12 hours would have elapsed. The question must be asked, if this sector of workers did not appear before you, it was not contained in the substantive matter that was before him. The matter was EPA versus G4S. What influenced Mr. Achong to make such a determination against a group of workers that he has no jurisdiction to pronounce upon? None whatsoever. That decision is truly astonishing and was over now, and I want to bring this home in a particular way. This judgment was delivered in 2015. In 2016, my apologies. In 2015, there was a judgment in the General Services coming out of Tobago, which already would have ruled that the security officers were in fact entitled to overtime after 8 hours. But in 2016, unprovoked, because the matter was never before him, he pronounced that they were only entitled to overtime after 12 hours. And everybody played Trump and follow suit, and security officers were deemed to be 12-hour work industry and overtime only after 8 hours. Another troubling matter arose in 2014 when the RBC officers were retrenched. The EPA took the matter to the Special Tribunal. In this case, the tribunal ruled that because there was no branch board at the RBC, the EPA could not represent the officers. That is despite the fact that the Estate Police Association is the only lawful body that can represent estate police officers in Trinidad and Tobago. That is according to law, Supplemental Police Act Section 38. So when he ruled that the association would have judicially reviewed it and sent it to the High Court, the High Court agreed with the Special Tribunal that we were not, in fact, entitled to have any local standby to represent the officers at RBC because there was no branch board. That is despite the fact that contained in the law, in the regulations 9 and 10, there are provisions for representation by a branch board and representation representation by the Central Committee, which we represent. So, dissatisfied with that ruling of the High Court, we went to the Appeal Court, and the Appeal Court agreed with the association. They agreed that the Estate Police Association can represent estate constables because there is a central committee in place. They also pronounced that the Special Tribunal is an inferior court, is an inferior tribunal, and their decisions can be reviewed for whatever reason. Astonishingly, after that judgment would have come out, the Special Tribunal decided on its own to go to the Privy Council, not the RBC, where the matter was with, So we had a matter, EPA versus RBC. Then the appeal to the Privy Council would have read the Special Tribunal versus the Estate Police Association. Now, I want people outside there to understand that this is the judicial body that we go before to get justice, taking us to the highest court in the land. So how could we get justice before this tribunal who taking us now to the Privy Council? The Privy Council ruled that the Special Tribunal, and I want you all to hear this, and I want you all to print it because we say it over and we have to keep repeating this. The Privy Council ruled that the Special Tribunal lost sight of the principles of impartiality and neutrality, and it acted as if it had an interest in a third party. The third party here would be RBC. So what the court was saying, that the actions of the Special Tribunal is in line with a third party, as if it had an interest in a third party. The Privy Council further stated that the matter is referred back to the special tribunal to be heard. And if possible, nobody who had a hand in the decision to send this matter to the Privy Council should sit and hear it. Trinidad and Tobago, comrades, everybody present. We met last week, Monday, in a mention and reporting, and we were told by Mr. Achong that there are dates for hearing in 2025, in April 2025, and in fact, he will head the quorum for that hearing. So here you have a situation where the Supreme Court, the supreme authority, the final court of appeal, says that nobody who has a hand in hearing this matter should sit and hear this. Mr. Achong is the only surviving member of that quorum who sits presently on the special tribunal. And we now have to go back to present the matter to him. How could that be justice? Justice must just only be done. It must seemingly be done too. How? Why are we allowing this to happen? There's no provision in law for the recusal of the chairman of the special tribunal. There are provisions in law for the recusal or the absence of the president of the industrial court. There's a vice president. There's a vice president of the Senate who sits when the president is out of the country. There are persons who are appointed to act for the prime minister, for the chief justice. Yet, they're saying that there's no provision for the president, the chairman of the special tribunal, if he's absent. We wrote to the Attorney General asking him to correct that. We received no response. But what we receive instead is that the chairman of the special tribunal is indicating that, listen, I am going to hear this matter. Regardless of the morality of it, the whole look of it, I am going to hear this matter because I am Lawrence Achong. I am the chairman. I am Lord of all I survey, and I will sit here and judge this matter. Comrades, on September 28, 2021, the EPA appeared before the tribunal in a matter ST 35, 2018, which was a medically boarded issue. A company would have medically boarded a person, and we appealed on the process of which they used to medically board the person. So that was immediately after we won the ruling at the High Court, at the Appeal Court in Trinidad. And when we appeared, now remember, this is a branch, but this is a matter that actually had a branch board live. So it was a live issue. And he got up, and he sat in fact, and he said, I do not agree with the ruling of the Appeal Court, so I am not going to hear any matter concerning the EPA until it has been determined by the Privy Council, and walked out. The 28th of September, 2021. I can say these things without fear of contradiction. Whatever I speak here is according to fact. We are making no allegations here. We are just presenting the facts, right? So what happened then? This person who was awaiting, this matter arose since 2016, got a judgment because of his delay in 2021, got a judgment in 2024. When that could have been made, people, since 2021. But because of the arrogance and the vindictiveness against the association, hey, we agree, well, move from here and dismiss and walk out on the representative body by law, Just get up and walk out of the court. And in the latest ruling, which has precipitated this particular meeting, which affects everybody who goes before the special tribunal, the central bank ruling, whereby the Estate Poor Association had a dispute with the bank concerning that they would have given Big Woo, the other representative, majority representative union, at the central bank 14% for the 15 to 17 period. and offered 9% to the EPA. On matters of equity, we decided to send this matter to the special tribunal for hearing, with the understanding that at the least the association would have been getting from the court would have been 9%, because that is what the employer would have indicated that they are willing and able to pay. They were willing and able to pay. And all their arguments, in their arguments and evidence and arguments before the court, was that this is what we can afford to pay. The central bank is the repository of all fiscal data, and they know all the reports from the IMF and all of that, the state of the economy. Yet, when presented to the special tribunal, remember they never withdrew the 9%, the tribunal ruled that the 9%, that even the offer of the 9% is wrong. So that the employer offering 9%, the special tribunal decided that they're wrong and instead awarded 6% to the Estate Police Association. Who we really negotiating with here? Somewhere along, somebody must ask, who we really negotiating with? Because if the employer is saying all evidence and arguments, 9%, but when we go before the judicial body, they say, no. 9% is too much for all you. 14% is too much for all you. 13%, 12% is too much for all you. Take 6. 8% is too much for all you. Take 9. Take 6. So I don't know if the next time the central bank wants to engage in negotiations, or any employer wants to engage in negotiations, they probably should go before the tribunal and ask them how much to give. Then that's what you have to do. Because if the association or any other union disagrees and goes before the tribunal with an agreed or offer on the table, and then the tribunal has the power to kick down the offer, then where are we going in this matter? Where are we going in industrial relations? Where are we going? This is the burial, you know. When we say that this whole thing was dying, the negotiations dying, the collective bargaining dying, this is the burial here, you know. This is the absolute burial. How could we now face this particular tribunal? This tribunal now has become a hostile environment to labor, a hostile environment to the Estate Police Association, a hostile environment. How could we go? We have to go before him, not back now for the RBC judgment. He pronounced on security officers at time and a half versus double time. He walked out of a meeting, of a hearing with a person. He took 2.5, and I wanted to forget to mention this. This judgment took 2.5 years to come in. This particular central bank judgment was about 2.5 years in coming in. We wrote to them, asked them, well, what going on with this judgment? It's holding up the next period. No response. 2.5 years it took for this judgment to come, to tell the association that they owed him and the members that they could only get 6%, because I deem that so. I so deem it. When labor speaks, everybody discards. Oh, they just rabble-rousing, right? Comrade ED Short and CWU and SWWTU, everybody just rabble-rousing. You understand? So, where do we go? Not for justice, to a place where we expect to have some sort of impartiality and neutrality? Could we expect that now with this ruling? Where do we go? As a nation, we sat down and allowed an ex-cabinet minister to sit in judgment on the special tribunal, where the government, as an employer, will appear before him. And that cabinet has the power to say whether or not your contract continue or not. right? So you get to pick your team. You get to pick your henchmen. So if I am dependent on you for my contract, and you have to, there's a dispute, and you are involved, how could I rule against you? How? And this is clearly what we've seen here, you know. This is clearly what we've seen here. So that entity such as the central bank could be told by the special tribunal that they don't know what they're doing. All the technocrats, the governor, the board of the central bank, they don't know what they're doing. When this 14% was given to Bigu, the board would have looked at all the data and they would have sanctioned 14%. When the 9%, the board would have sanctioned that. All the technocrats in the central bank, but the technocrat in the ministry, in the special tribunal, deemed that no, all are wrong. All are wrong. Go back and give them 6%. That's what they deserve. Them is dog. They deserve time and a half after 8 hours. That's what they deserve all of that. They took me to we went to the special tribunal and the Privy Council. They took us there. We didn't take them there, you know. Remember, it's the special tribunal who took us to the Privy Council, and the Privy Council said this same chairman here, as being part of that particular quorum, lost sight of impartiality and neutrality. But they want us to go back now and stand in front of him to argue matters. It's a decision that is taken by the powers that be to allow this thing to continue because they know about it and they could change it. A simpler thing is to say, listen, move from the special tribunal and go in the general services and allow the president to appoint somebody now as the chairman of the special tribunal. If all don't want to move him completely out. Or you go into the Civil Service Act and you make provisions for that. So when he comes before us and says that he is going to hear it, we have to swallow that and go and face him. We submit that this is punishment meted out to the Estate Police Association. Continued punishment. I don't know which estate police officer thief he found in, but it's continued, sustained attack on the security industry and the Estate Police Association. I can't sit here as the president and say nothing. And that is what they want to know. They want to beat you into submission. You must say absolutely nothing. But you have poor people. You have poor people being made provisions by law for time and a half after overtime, and we know people working 48 hours at straight time in the security industry, and you decide unprovoked that they don't deserve that estate police don't deserve that, and that even when you win at the appeal court, we don't deserve that. You have to spend taxpayers' money to send it to the Privy Council, and you lose. And they say that you lost sight, the tribunal lost sight of the principles of impartiality and neutrality. If a judicial body loses sight of that, then what? Do you not have a sense of decorum and morals? You say, listen, I need to step down. I need to step down. But no, probably persons will not allow him to step down. So Trinidad and Tobago, this is an account of years of consistently bad rulings against the Estate Police Association. We now have to go back to make a new dispute to try and fix some of those judgments that were made back in 2014 and 2016. The officers are disenchanted, they're disillusioned about what is happening. This is union busting. So what it says to the membership, that if you go into the tribunal, You had 9 and you come with 6, and you come back with 6. Then better we ain't join the union, we ain't join the association. And that's what they want, you know. They want the membership. They get so disorganized that they will drop out of the union, drop out of the association, and then you will kill Labour. I want to rest my case right here, my lord. Thank you. Any questions? Yes. Yes. Have you written to the president or the international court president? Yeah, we wrote, and we got. As a matter of fact, comrade here could speak to that. Who you all wrote to, and what was the response?
Actually, through the joint trade union movement, all unions would have signed after it was penned by the Secretary General for Joint Trade Union Movement, signed and agreed to the revisiting the position that Mr. Larry Armstrong currently holds. And they would have written to, if I'm not mistaken, both to the president and also to the government officials, because this has to be fixed within law. You cannot have the Privy Council making a judgment, lacking, indicating, and we beating around the bush. We are saying that the Privy Council indicated that it is the special tribunal that has lost sight of impartiality and whatnot. But the special tribunal is not an inanimate object. It's not a desk, it's not a chair, it's not a building. It's an individual. It's individuals. And there's one individual who currently remains in that position. So when the Privy Council is saying the special tribunal has lost sight of impartiality, one of the founding principles of the court, then they're really speaking directly to Lawrence Armstrong has lost sight of impartiality. That is what they are saying. And the only way this could be resolved, and it is something that I personally and hopefully the entire joint trade union movement would be writing again to the Attorney General, is to correct a particular part in the act, which speaks to the chairman of the Essential Services Division must be the one sitting as the head of the special tribunal. That particular act, because that is what they are using to go on that to say he must remain in that position. Their hands are tied. We have witnessed time and time again the government quickly has brought amendments to the bills, different acts in Parliament, and they have do so without hesitation. And this is a critical juncture where they ought to be able to do that, to correct that anomaly. They cannot hide behind, well, that is the law. The government has to be able to correct that. Yeah? Well, that should have happened a couple months ago, since the judgment was delivered. A right-thinking, conscientious government should have done that, since that damning judgment would have come out by the law lords in England. Very damning judgment. But you're getting responses from the president and the government officials? You ever responded? No response, unfortunately.
Yes. Yes. In a mention reporting, before the matter is heard in the court, the mention reporting will be, you're meeting what you call mention reporting, and he indicated, right, at that official meeting, that he will be hearing the matter. Mr. Buckley was the person who would have taken it.
Yes, the 5th. Robert Utley, General Secretary. I heard the goodly gentleman with my own 2 years stated quite clearly that he will be hearing the matter in addition to 2 other justices from the Essential Services Division that he choose as indicated by the law. Right? No, not the same 2 from before. As my president said, Mr. Achong is the only surviving member from that panel that originally ruled on the RBC matter. So therefore, he is the person that ought to recuse himself. Because as my president stated, when the court spoke, it then spoke to 3 judges who happened to still be there. Only 1 person was there, so that is the person they were speaking to. Ought not to. Now they use the word ought not to, but you know those gentlemen are quite diplomatic. They won't tell a government to, hey, go and do this in no uncertain. They would use the required language, but at the end of the day is, hey, don't let a person sit there. Mm-hmm.
Are you all considering any legal application for the High Court to review that?
Well, we did have a meeting with our lawyers, and the lawyers say that they are currently exploring all legal arguments to see if it is possible to have him recused from that hearing, that matter.
But as you said, it is law
It is law,
that he sits there.
but he could challenge. You see, and the senior counsel who we are dealing with, he would have indicated that he would review. So we are waiting on his direction as to what is the next move concerning that particular matter.
So basically, it's either he resigns, he or the legislature changes.
Yes,
Voluntary change, but
something has to be done. Yeah.
you all, if nothing is done,
If nothing is done, well, you see again,
are you all going before the morning?
well, we will have no choice. We will have absolutely no choice if nothing is done. So here we will have again no other choice, because you see, power, this is what power is about, you know. Power is about grinding it down and taking it by force, you know. So regardless of what you say, regardless of what the Privy Council say, right, I am not going to do what is necessary. When they say, if possible, it is possible, you know. It is possible. So when they say if possible, they trying to use that as an oust to say it's not possible. But it is possible, just that certain actions have to be taken.
Well, we don't go before the special tribunal, but we go before the Essential Services Division, of which he is chair also. And without almost by default, we could tell which matters we would win, which matters we will lose, based on if that particular gentleman sits as part of the 3-member panel. So we actually had a situation recently which we had to appeal, where we had one particular matter facing Northwest Regional Health Authority, where we won that matter. So obviously we took the very same matter to Southwest Regional Health Authority to challenge that particular practice they were doing in Southwest, the exact same matter. The only difference was Southwest Regional Health Authority, where it was impacting a worker who only worked a year and a half. In Southwest, that worker worked 10 years. And they were telling that worker they have broken service after 10 years of continuous employment. And the court, surprising to us, ruled completely opposite from how they ruled 1 year prior. The very same judges, the same TTRNA, and this particular judge would have made some pronouncements and reverted. So we can't understand what evidence they utilize, what rationale they utilize. And we really would want to see, you know, every unfair practice engaged by the industrial court or perceived to be engaged by the industrial court, every action that is not in line with good industrial relations practices, every decision that seems counter what is fair and reasonable really taints a negative light in the image of persons who have to go before the court. It really taints the court, and that ought not to be. The whole reason for the industrial court, the whole reason for the Industrial Relations Act, the whole reason for industrial peace is being whittled away systematically, continuously, yet incrementally by the actions of Lawrence Atchong. And they are really good judges in the industrial court. We want to reiterate that. This is not an indictment on the entire court. But as long as Mr. Laurie Atchong remains in that seat, with his lack of neutrality, his lack of impartiality, it weakens the image of the overall court. So all members of court are now tainted by the actions of him. And it's really unfortunate. And you asked an important question. You know, what happens next? And it really comes down to the Attorney General of Trinidad and Tobago and the government by extension of Trinidad and Tobago. Because it is either they remove him, as they removed Deborah Thomas Felix, one of the most excellent presidents of the court has ever had. So they have the ability to move him, or they amend the act to allow the vice president to be the one chairing the Essential Services Division subsequent to the special tribunal. Yeah, so they have mechanisms to resolve this. It is if they have the will, so they cannot be extrapolated from this situation. The government has a direct role to play within this, in resolving this particular matter. Yeah.
So your matter is slightly different from
Yeah.
overall it's safe to say that trade unions don't really have faith in that job.
Well, definitely. I have not, we are part of joint trade union movement, and I have not heard one single leader, one single executive express confidence in Mr. Lawrence Atchong.
Comrade, I would say it and repeat it, that the special tribunal is a hostile environment to the estate police and to others who appear before the special tribunal. That is how we feel. We would have systematically shown here today all the judgments, the incorrect pronouncements that were made by the special tribunal, and there's one constant in all of that, which is Lawrence Atchong. There's one constant. Contrary to law, he deemed security officers to not have the access to overtime after 8 hours. And I'm sure everybody here who listening would have known or heard that you had to work 12 hours in the security industry to get overtime. That was contrary to law, yet he made it. Yet there was before him. If the special tribunal says that, the Privy Council say that you acted as if you have an interest in a third party, the third party being the RBC, did not appeal the matter to the Privy Council, were not even notarized in the matter. Yet it went there at the expense of taxpayers' money. Pay for King's Counsel, fees for filing and all of that. Taxpayers' money pay for that. And yet, he sits in judgment, sits up there. You know, when you go, you're down here, and they're up there, and he sits in judgment. Right? And he comes to us and say, you, I will hear that matter. There's nothing you could do. Right? So you know in the Greek mythology, I'm thinking they have Olympus, the gods up on high. Zeus and all of them sit up there and they look down on us. Right? And they deem whatever, right? Come down and they play with us and they go back up. That is what happening here in Trinidad and Tobago. Security, we don't think that we could go before the special tribunal under Larry Archong and get justice. Mm-hmm. In this matter for the RBC, we don't think that we could go before the special tribunal and get justice. We clearly didn't get justice in this central bank judgment here, where the employer is saying 9 and you saying 6. Clearly, it has never happened. I've polled a number of industrial relation consultants, people in the industry, people who in the Cipriani, all over, and nobody could recall ever having a judgment where the court or the special tribunal did this. You may go and if you go now, they may not give you what you wanted, but they never give you what less than the employer was prepared to give you. Because the basic tenet of it is that what is the employer can afford. And if the central bank could say they could afford, I bet you the central bank could afford it because it's only 54 officers. They pay 14% to 90% of the bank. Over 500? And 54 officers, you're refusing to pay 14%. And then the central bank, the Privy Council, the Tribunal come and say, not even 9 good enough for you. 6. That's how they value the work of the estate policeman. We can't get parity with nobody. It's the same thing Tiantec do. And it's the same man who come and say 000. Remember that? Tiantec 000. There was 6% on the board in Tiantec. 000 is what we get. I rest my case. But again, that's it. Thank you all for coming. Right. So I want to again thank the comrade Shane Buru from the Steel Workers Union, and of course our comrades from the Estate Police Association, Comrade Otley and Comrade Bagwandin, and of course our good partner TTNA, Comrade Edie Short, and Joanne Oji from the Communication Workers Union for coming to support the association in this press conference. Thank you very much.